Fixtures. List included items, lighting, built-ins, garage, remotes. That long list of items.
But don't lenders, isn't there an issue that lenders may take if you have, because I have some older realtors that are always like, can you remove the fridge? I don't want the lender to see that.
I go back to like when I was taking over the contract. We have our rules and guidelines that we go by, and they have their rules and guidelines to go by. Our job is to put it under contract. Where agents and contracts get messed up is when we start trying to think what the lender is or is not going to require. I would say put it all together. Then if the lender says, hey, we can't have the fridge a part of the contract, that's where you strike it from the contract and then do an addendum. And then you don't send the addendum to the lender. And I'll be honest, this is what lenders tell you. This isn't Peter saying, I'm not trying to violate any law. The lender doesn't want to receive it. And the example I'll give is, it's like the inspection report. If you email an inspection report to a lender, and that lender sees it, they are now obligated by their rules to make sure everything on that inspection report is completed. So why send it to them? They don't, trust me, they don't want to see it. Let the lender tell you what needs to be included and what needs to be excluded. Hey, I need this to be stricken from the contract. Strike it and do an addendum. Yes?
There are lenders out there, such as Wells Fargo, who will send an email requesting the home inspection report, and then you can just kindly tell them no.
No. Absolutely. Well, remember, the disclosures are not a part of the contract. That's the other thing. It's not a part of the contract. You don't need it. If they ask for the disclosures are not a part of the Oklahoma real estate sales contract. You don't need that. If they ask for an inspection report, you don't need that. It's not a part of the contract. That has nothing to do with the contract. So yes, tell them in a more pleasant way, but yes. All right. The additional inclusions and exclusions, what shall remain with the property? If there is a standalone electric hot tub in the back and they want to leave it, put it there. If there's something that they want to take with them, write it down. It does not matter if you think that no one's going to ask for it. Because I think I've told this story before, but I was like one of the earlier years in listing a house. I'm out there, I'm listing this house, and she had to be the exact replica of the mirror from The Ring. If you remember, it was scary looking. It was the faded glass. I swear somebody looked back at me that wasn't my own reflection. It was the scariest mirror I've ever seen. And she was just like, I want to save that mirror because the devil gave it to me. No, she didn't say that, but she was like, I want to keep this mirror. I want to take it with me. And I'm like, it's not a problem. They won't ask for it. It's in the middle of it was in the middle of the hall too. It wasn't like even in front of anything. It was like in the middle of the hall. And so I was like, don't worry about it. Nobody's going to ask for it. It's good. Because, I thought, like, first offer received, mirror. They wanted the mirror. And she was mad. I told you they'd want my mirror. I was just like, oh my goodness. So include it, right? Just go ahead and write it in there. Even if you think to yourself, my opinion is anytime the client asks you, hey, I want to make sure that I'm writing that this stays with the property. Don't tell them, oh, they know. Just write it down. Because you're better to represent the client than try to show how smart you are. Make sense? All right. Fixtures. I want to go ahead and give this definition. So this is what a fixture is. So Oklahoma courts and real estate commission use a 3-part test to determine if an item is considered a fixture. So real property versus personal property. Number 1, annexation. Is it permanently attached to the property? Like it is screwed in, bolted in, nailed in. It is there. All right. Number 2, adaptation. Is it adapted for the use of the property? So a built-in oven versus a microwave that sits on top of the counter, right? A built-in microwave. That thing is attached. It's meant to stay with the property. Or the intent. Did the installer intend for it to be permanent? Right? So somebody installs a floating shelf. Was the intent of the installer for that floating shelf to be permanent? Sometimes you might see that was like a bookshelf. I've seen it where it was a bookshelf, the trim went up to they took this whole bookshelf with them. They're like, oh no, it's a bookshelf. But the trim stopped on each side of the bookshelf. So what was the intent of the installer? That bookshelf was always going to be there because the trim did not go behind the bookshelf. So it's kind of like when if you'll write anything down from this class, write this note in your notes down, and somebody, if your client goes, what's the difference? You can speak annexation, adaptation, or intent.
How do you prove intent?
But just like that, like I was saying, like if the trim stops where the bookshelf is, it was permanent. Where's a hole drilled in the wall to make it stay.
Like the microwave that's built up into the cabinets. That's permanent.
Yeah, that's permanent. If removing it leaves damage, like something that needs to be repaired in the property, the intent was if it would always be there.
Like if your trim looks junky, it's...
Yeah, if you have holes in your trim missing, if you have holes in your wall missing, right? Same thing with like TV mounts, right? That could be argued the intent was for those to be permanent because you're putting 4 lag bolts in the studs, and when you remove them, you now have holes in your wall.